The probate courts will determine who is going to be inheriting your rental properties when you pass away without a will that gives instructions on how to distribute those assets. So the reason being is that when you pass away with those rental properties in your personal name, but you do not have a will, those assets will get split per the intestate laws of your state. As an example, in Georgia, your assets get split evenly between your spouse and your kids, with your spouse getting a minimum of 1/3. If you don't have a spouse but you do have kids, the kids will distribute those assets evenly between themselves. If you don't have a spouse or kids, your parents and then your siblings will get those assets. So if you want to be in control over how those assets are being distributed out to your family, you can set up a will. A will force all of your rental properties to go through the probate process, but it will determine how they're being distributed. If you set up a revocable trust, that will allow you to avoid the probate process and also control the distribution of those rental properties. You could keep them inside of the trust to be managed on behalf of your family, or you could distribute those properties out to your kids in a controlled fashion. So it could be age-based distributions, event-based distributions, etc. Or you could keep the rental properties inside the trust to be managed on behalf of your spouse to take care of them throughout the remainder of their life.